Yes, Mr. Cooper.
My lord. Can I just start with a few preliminary matters so that I don't forget them and to get them out of the way? First of all, I think Mr. Milsom's solicitors have provided the court with copies of the recently passed Armed Forces Commissioner Act.
Yes.
2025. We just thought the court ought to have that. It has no bearing on this appeal directly and makes no substantial difference to the service complaints process, but the court ought to be aware that the Ombudsman is shortly, when the Act is brought into force, to be abolished, the Office of the Ombudsman to be abolished and replaced by the Armed Forces Commissioner, so far as the service complaints process is concerned. Other than that change in the person with responsibility for overseeing that process and hearing complaints about it, the only change to the process itself is a non-substantive one to the person who decides the disability. But all the court ought to be aware of that.
And will it all take effect on the day in which the Act is brought into force in respect of existing disputes, or will there be sort of transitionals, or don't you?
I don't know, my lord. The expectation currently is that it will be brought into effect from April next year. I anticipate that the Commissioner will immediately assume responsibility for everything, because otherwise you would have two officers operating in tandem, but that's an assumption rather than something that I know.
If it assists, my lord, that's my understanding as well.
Good, thank you.
Secondly, by way of preliminary observation, I agree with Mr. Milsom that this is a case where this court can and should decide all the issues for itself.
Yes.
It's not a case where, with the greatest of respect to them, any particular deference need be shown to the analysis or balancing of considerations by the lower courts. And so equally, without meaning any disrespect to the tribunal or the Employment Appeals Tribunal, I will not be taking up much time with reference to their decisions. In my submissions, I'll focus on the arguments that I invite this court to accept. Thirdly, it's worth starting with these two observations. First of all, the particular effect with which the court is concerned in this appeal is a very narrow one. It arises only where a serving service person wishes to complain of discrimination in relation to the conduct or outcome of a service complaint. It does not apply to any other discrimination in connection with or in relation to a service person's service, and that's illustrated by the facts before this court, procedural facts before this court, that this claimant's claim 1, I can call it that, covers all of the substantive complaints that she originally brought by way of a service complaint. And it's only in respect of claim 2, which is about the narrow issues of alleged indirect discrimination in the conduct of the service complaints process by not holding an oral hearing, and alleged victimisation in the decisions under that process. Only in respect of that complaint that the issue arises. And that leads on, secondly, to this observation, that that particular effect is not the result of either Section 121 of the 2010 Act by itself, nor of Regulation 3.2 of the Miscellaneous Procedure Regulations 2015 by itself. It's the result of the combined effect of those two provisions, and I'll be showing the court in due course why in my submission it can and should be concluded that that is an intentional combined effect. But the fact that it's the combined effect, and that one of those provisions is a matter of primary legislation and the other is a matter of subordinate legislation, does have implications if this court concludes that the combined effect gives rise to a breach of Articles 14 and Red Book Article 6, it does have implications for what the potential solutions, plural, might be, what the implications for this particular case might be in light of those potential solutions, and also on the appropriateness of a declaration of incompatibility, which is of course only available in respect of primary legislation. So I'll address those implications as we go, but it's important, I think, to frame the whole argument by noting that it's that combined effect that we are ultimately concerned with. Turning then to the structure of my submissions, I do propose to put the cart before the horse and start by addressing whether, on the assumption that there's a breach, it is possible to read down the legislation under Section 3 of the Human Rights Act. And then I'll turn back to look at whether the effect of that interaction between the two relevant provisions does give rise to a breach at all. The reason I'm going to address the issues in that order is because a central aspect of my submissions on read down will be to identify the legislative purposes and other considerations that are in play and the potential options that might be available if there were a breach in order to remedy that breach. And doing that by way of groundwork will, I hope, then inform what I have to say about whether there's a breach at all, because it will have laid the groundwork for what are the various considerations that Parliament was balancing in the particular solution that it has come up with, and why those are in my submissions an example par excellence of Parliament exercising its constitutional function of deciding within the margin of appreciation available to it how to balance the relevant policy considerations in circumstances where there is no perfect solution that fully achieves all of those policy considerations or all of those policy objectives. So I'd like then, before I get into the detail of my submissions, to give you the headlines, and I'm going to do so under five broad propositions or five broad areas. First area, determining the appropriate procedural rules applicable to complaints about discrimination in relation to the conduct or outcome of a service complaint requires at least three relevant objectives or policy considerations to be considered and balanced. And those are, firstly, the objective of affording the armed forces an opportunity to address any alleged discrimination via the service complaints process before a tribunal claim might be brought. Secondly, the objective of limiting satellite litigation in relation to the service complaints process. And thirdly, the objective of ensuring that service personnel have appropriate redress for any discrimination that they might suffer, including in the context of a service complaints process. The second area of my submissions, or second proposition, is this. Parliament has made a deliberate choice about how to strike the balance between those different considerations. And if that choice were to entail a breach of Article 6 and 14, there would be at least three different options for rectifying that breach, each of which would involve striking a different balance between the three objectives or considerations that I've identified. third proposition then is that it is consequently not possible to read down the legislation either in the way proposed by the claimant or in the way proposed by the Ombudsman, or at all, because both of the well-established limits on that ability are present. That is to say, reading down as suggested by the claimant would cut across the deliberate choice that Parliament has made as to how to balance the relevant interests. And secondly, because there would be several ways of resolving any breach, the choice between which would involve balancing of considerations which calls for legislative deliberation. The fourth proposition, then turning back to the question of whether there's a breach at all, is that the consideration of the relevant objectives and considerations shows that the balance which Parliament has struck is justified. The differential treatment here relates to a very narrow category of claim and is not based on any of the core grounds protected under Article 14. Parliament therefore enjoys a wide margin of appreciation, which it will only exceed if the measure is manifestly without reasonable foundation. As with all legislation, balancing the relevant considerations necessarily involves drawing distinctions, and, as is often the case, there is no perfect point at which to draw the line. There will inevitably be some compromise of one or more of the competing objectives, or some degree of anomaly. But fundamentally, the point at which Parliament has chosen to draw the line in this instance is well within the margin of appreciation. And then the last area or proposition is that if this court were to be against me on breach, i.e. to find that there is a breach, but with me on read down, so to find that it's not possible to read the legislation down in the way proposed by the claimant or at all, then the issue of whether to make a declaration of incompatibility would arise. And in my submission, such a declaration would not be appropriate in this case, essentially on the ground that any incompatibility does not arise from Section 121 of the 2010 Act by itself, but from the combined effect read with Regulation 3 of the 2015 regs. So the appropriate course would simply be for the court to set out its analysis and conclusions and then leave it to the Secretary of State and Parliament to consider which of the available options is the appropriate one and how to give effect to that by way of primary and or secondary legislation. So those are my submissions in overview, and let me turn then to the first area and issue, which is read down. And I begin by just identifying the well-established limits. They are set out by Lord Nichols in the well-known passage of paragraph 33 of Gaydon and Godin-Mendoza. I don't propose to turn it up unless the court would find it helpful, but it's at page 561, tab 29 of the authorities bundle. The two limits are that read down is not possible if it would be inconsistent with a fundamental feature of the legislation, i.e. it must go with the grain of the legislation. And secondly, a read down is not possible if it would require the courts to make decisions for which they are not equipped. And I'm quoting now, there may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. And in my submission, as I hope to show, that is a precise description of the circumstances in this case, if the court were to find that there's a breach. Before I turn to the first of the areas identified in my propositions, which is to identify the relevant statutory purposes, it may just be helpful also to make reference to the similar limits that apply to the possibility of disapplying subordinate legislation. So, of course, the duty to interpret the legislation compatibly applies to both primary and secondary legislation, but in the case of subordinate legislation, the courts may disapply or ignore that legislation where a compatible interpretation is not possible. But there are, again, limits on that, and the relevant authority to look at for these purposes is, I think, one that Mr. Milsom handed up after the authorities bundle was produced, RR against the Secretary of State for Work and Pensions, 2019 Non-Weekly Law Reports 6430. And the particular facts and issues in that case needn't, I think, detain the court. But the relevant passages begin at paragraph 27, for my purposes, on page 6440 of the report. Where Baroness Hale, giving the judgment in the Supreme Court, says, picking up 3 lines into paragraph 27, there's nothing unconstitutional about a public authority, court or tribunal disapplying a provision of subordinate legislation which would otherwise result in their acting incompatibly with the Convention right, where this is necessary in order to comply with the Human Rights Act. Subordinate legislation is subordinate to the requirements of an Act of Parliament. The HRA is an Act of Parliament and its requirements are clear. And then she illustrates the distinction drawn between primary and secondary subordinate legislation in that regard within the statute. And at paragraph 30 says, contrary to the Secretary of State's argument, Matheson was not a one-off as shown by the authorities listed above. The courts have consistently held that where it is possible to do so, a provision of subordinate legislation which results in a breach of the Convention must be disregarded. There may be cases where it is not possible to do so because it is not clear how the statutory scheme can be applied without the offending provision. So the first limit on disapplying subordinate legislation is where disapplying it would have knock-on consequences within the statutory scheme, and it's not clear how those consequences would or should be resolved. And the second limit in respect of disapplying subordinate legislation may be inferred over the page just above letter B, where in holding that it was perfectly possible to disapply the legislation in the case before the court on that occasion, Baroness Hale observes that there is no legislative choice to be exercised, and so inferentially that would be a further limit where resolving the disapplication of the particular provision would result in a legislative choice having to be made in respect of how the scheme operates without it.
Well, doesn't it come to this, that if primary legislation is incompatible, or secondary legislation is incompatible, or a combination is incompatible, but there is more than one way of resolving the problem, we shouldn't do any drafting.
Yes, that's what it comes to.
Yeah.
So can I turn then to what the relevant statutory purposes or considerations are in this instance? There are, as I indicated, there are 3 of them. The first is that the purpose of section 121 of the 2010 Act itself is to require that any matter to be the subject of a claim under the Act should first be raised through the service complaints process so as to afford the relevant service an opportunity to restore the military covenant. And that is supported by authority at the Employment Appeals Tribunal level. We needn't go to all of them, but by way of most recent example, Edwards and the MOD at tab 60, within that at page 1734 of the bundle.
Before you go any further, when one's considering whether what the fundamental purpose of the legislation is it appropriate to go straight to the individual section as you've done, or is it not the court's task actually to look at the whole legislative picture, of which section 121 is but a part? I just wanted to establish what the starting point is for this exercise, because they might produce different outcomes.
Yes, in my submission, it's both. So you have to look at
you have to look at 121 in its context.
121 in its context.
So one considers what are the purposes of the Equality Act, and what part is 121 playing in that, and what then of the situation that arises here. Whereas if you simply just open and close the book on the single section, you're not likely to get to the right answer necessarily.
Yes, I agree with that. So it's what are the purposes of the Equality Act? What part does Section 121 play in that? Does Section 121 have other objectives as well, which are fundamental to that provision? And that's what I'm focusing on as my first of them.
Absolutely. Well, it wasn't in any way a partisan point I was seeking to make. I just wanted to understand what you took, and I think this must be probably common ground.
Yes.
Is when we're talking about the fundamental aspects of the legislation, it's the legislation as a whole. And then one looks in at what's particularly involved.
Yes, this may be a difference of emphasis rather than difference of substance, but it's the legislation as a whole and the particular provision that one's looking at, because there may be, and there are here, particular purposes of the particular provision which are distinct from the overarching purpose of the legislation as a whole. And I'll come to it. Plainly, the overarching purpose of the Equality Act as a whole is to eliminate discrimination within the spheres to which Parliament has decided it should apply, and to provide redress for that in the way that Parliament has decided there should be redress. And then within that scheme, Section 121 has a particular purpose, which is what I'm identifying as my first of the three purposes that needs to be balanced, which is that in the case of armed forces personnel, there should first be a service complaint so that the armed forces have an opportunity to redress or rectify any breach of the covenant before the matter is dealt with by the Employment Tribunal. And so that purpose is identified in Edwards and the Ministry of Defence, which is tab 60 of the authorities bundle, and within that paragraph 88 subparagraph 2 on page 1734 of the bundle, page 715 of the report, where Mrs. Justice Heather Williams says, as identified in Laudi, the purpose of the statutory scheme is to ensure that complaints of discrimination are in the first instance determined by a body deemed by the legislature to be the appropriate body for resolving such disputes, with the ET dealing with the matter at the next stage. Just pausing there, this is part of the answer to the Michelin point that the ET is always the specialist tribunal that ought to be deciding issues of discrimination. In the case of the armed forces, the structure is that the Ombudsman is in the first instance the specialist body charged with deciding complaints by members of the armed forces, including expressly, we'll come to it, expressly complaints of discrimination. So the Ombudsman does have that expertise and is charged by Parliament with exercising that expertise.
Does Section 121 require the service complaint to have been decided before you can make an ET claim?
It doesn't any longer, no.
No. So that's not quite right, is it?
Well, it must be modified in light of the changes to Section 121 to this extent, that it requires the complaint to be made so that the armed forces have the opportunity to address it before the matter is dealt with by the tribunal.
Well, not necessarily, because you could issue both sets on the same day.
You could, but there are two.
Provided you did them in the right order.
you could, yes. But there are two reasons why there is that opportunity in practice. The first is given by Mrs. Justice Heather Williams just below letter F on the page we're looking at, which is that the normal practice is for the tribunal claim to be stayed pending the outcome of the service complaint. But even if that weren't the case, then the practical effect is that there will, at the very least, almost at the same time as the tribunal claim is brought, also be a service complaint, which gives, because the tribunal claim will take some time to come to a hearing and a determination, does in practice give the armed forces an opportunity to look at the service complaint and attempt to resolve the matter. Whether they take that opportunity is, of course, a matter for the armed forces and the way that they run their process. And if they don't, because they don't run the process well or because they choose not to, that's a matter for them. But the statutory purpose, for my purposes, the key point is the statutory purpose is fulfilled, that there is that opportunity for the armed forces in practice to consider the service complaint before a tribunal claim.
Let's suppose that they were very diligent and they immediately picked up the challenge of the complaint and started investigating it. And a complainant said, well, actually, I'm not prepared to engage with this because I'm going to the tribunal. I appreciate that's a completely different situation. But in that situation, really, the complainant would be considered within the armed services to be obliged to engage with their own complaint. And so one might end up with a situation where it was then considered withdrawn.
Yes. Precisely.
So that was really following from your suggestion that there was an opportunity.
Yes.
Because a complainant could scarcely start off and then simply not cooperate.
Yes, precisely. If the claimant ceases to cooperate, then that would be an implied withdrawal. If the service complaints secretariat write and say, we'd like you to respond to these questions or come to this meeting, and they don't, and they give them this opportunity. So that the statutory purpose is fulfilled, and that I put the matter in this way. This must be the purpose of Section 121 because it's impossible to see any other. And this is the purpose that's been identified by the AT consistently in the authorities, most recently reflected in this decision in Edwards. It's also common ground between both parties and the Ombudsman that is the purpose of Section 121. Again, just for your references, paragraph 47 of Mr. Milsom's skeleton argument at pages 199 to 200 of the core bundle, and paragraph 21 of the Ombudsman's submissions, pages 257 to 258 of the core bundle, both make it clear that it's common ground that is the purpose of Section 121. So that's the first of the three relevant purposes to be balanced. The second is that the purpose of the exclusion of complaints and claims about the conduct of service complaints pursuant to Regulation 3 is to limit collateral challenges to the service complaints process in the interests, we say, of maintaining high morale and discipline within the armed forces.
Well, if you're talking about service complaints about service complaint handling, then seems to me, and Mr. Milsom was disposed to agree, that there would be obviously a Russian doll's problem, irrespective of morale and discipline. It's just absurd to say you can endlessly complain about the way that the last panel heard your case. There'd be no end to it.
Yes. My Lord, precisely. So that's, if I could just take the court to the explanatory memorandum that accompanied the 2015 regulations, which is at tab 66 of the authorities bundle. And page 2004 is the relevant page within that. And I'm looking at paragraph 7.4 and the second bullet point. So the regulations in this instrument have the following aims. Second bullet point, by excluding matters from being raised as a service complaint, the intention is to prevent repeat complaints. So that's the, my Lord's point about the Russian dolls, and challenges to decisions made in the internal system or by the Ombudsman. And so that is broader than the specific Russian dolls problem. That is also to prevent collateral challenges, satellite litigation in respect of the conduct and outcome of the service complaints process itself. And
So, sorry to interrupt, Mr. Cooper, what's the reference to adequate alternative remedies?
that's my gloss on the words used there.
No, it says
Words
where
used.
adequate alternative
Otherwise,
remedies are
to
available.
exclude complaints where adequate alternative remedies are available. So that is a reference. So the first two are dealing with the exclusion under regulation 3.2. Perhaps if we turn that up at tab 12, page 143.
One, 143 core bundle.
Cool. The authorities bundle, I'm sorry, 143. So, subparagraph 3.2 of regulation 3 is the first two of those objectives. That's restricting the scope for challenge to the various decisions and aspects of the service complaints regime itself that are listed there. And then the third of them is dealing with, is referring to subparagraph 1. Person may not make a service complaint about a matter within the schedule. If one goes to the schedule, paragraph 1 at page 146, one sees there and over the page a long list of various types of decision, all of which have in common that they have separate and independent routes for challenge by way of statutory appeal or review or complaints to various bodies. So that's what the third of those objectives.
Thank you, that's helpful.
How does it work? This is all to do with things you can't make a service complaint
This
about.
is all to do with things you can't make a service complaint
Right. And it's said against you, but it doesn't say anything about things you can't go to the employment tribunal about.
It doesn't expressly. I'm going to come to that, my lord, but to foreshadow what I'm going to say, it is that it has always, at the point when the 2010 Act was passed, it was clear that certain matters could be excluded from the service complaints regime, and in fact, complaints about the outcome of service complaints were excluded at that point. And then in 2015, the 2010 Act was reviewed and amended as part of a package of primary and secondary legislation introducing the current regime in 2015, with all of the features that we're now focusing on. And so what I'm going to be submitting is that plainly Parliament must have understood and intended the combined effect that we're
The way it works, as I would understand it, is that if you want to exclude all of these possibilities, then a fortiori you want to exclude the possibility that it's going to be the same thing, but, quote, worse
Yes.
in the Employment Tribunal.
Yes.
And therefore I'm only reciting what I understand your thesis to be.
Yes, that's it,
Not
exactly.
agreeing with it, but therefore what has been done by the combination of the two pieces of legislation is entirely in keeping with what we see specifically with relation to service complaints.
Yes, that's it. So the second relevant purpose is to limit the scope for collateral challenge to the conduct or outcome of service complaints. And could I just make one more reference to authority at this point to show you that this is, of course, a perfectly legitimate purpose, including in the context of limiting claims for discrimination. So, in order to set up this point, can I just first take you to section 120?
I'm so sorry to interrupt, Mr. Cooper. Just before you do that, would I be right in thinking that tab 6, which is the 2007 regs, were the regs that were in force when the Equality Act was enacted?
And it's
At some point, are you going to explain how those work? Because
I am, for
okay.
your ladyship's, again to foreshadow, but I will come back to it.
Yeah.
Regulation 4 is the relevant regulation that excluded complaints, so service complaints, about the outcome of service complaints under those regulations, and therefore had the same effect as the one that as the effect that we're now concerned with under the 2015 regime.
And so what was the purpose of the, as I said to Mr. Milson when I asked him about it when he was making his submissions, the apparent interaction of Regulation 9(1) of those regulations and Schedule sort of paragraph 2 of Schedule 1 seems at first sight to be not to exclude something if it involves a complaint of discrimination. But it may be I've misunderstood that. You're going to deal with that in due course.
Let me deal with it now. So it's the same distinction is drawn in the 2007 regs as in the current regs. So in respect of the long list of things which have other routes for challenge,
Yeah.
in both sets of regulations, there's then an exclusion from the exclusion, which says you can bring a service complaint if your service complaint is, amongst other things, about discrimination
Yeah.
in relation to those other alternative remedies. But the same exclusion from the exception from the exclusion doesn't apply to the exclusion
Complaints
of
about complaints.
complaints about complaints.
All right, got that. Thank you.
So that's the point in relation to those, and I'll come back to it.
All right, that's very helpful.
But focusing for the moment on the second of the purposes I identified, so to limit collateral challenges to the service complaints regime, could I go to section 120 of the Equality Act? It's page 88, tab 9 of the authorities one. Just to identify as the context for the case that I'm going to go to, that subsection 1 is the subsection that confers a general jurisdiction on tribunals in respect of breaches of the Equality Act under Part 5 work. And that includes discrimination by what are described as qualifications bodies under Part 5. That is, bodies that are responsible for conferring rights to work or work qualifications required for work, such as the General Medical Council or those sorts of bodies. And at subsection 7, you'll then see that subsection 1A, so the jurisdiction of the tribunal, does not apply to a contravention of section 53, that's the qualification bodies section, insofar as the act complained of may, by virtue of an enactment, be subject to an appeal or proceedings in the nature of an appeal. So Parliament has, in this respect, as well as in the respect we're looking at, excluded from the jurisdiction of the tribunal claims where there is a statutory appeal or proceeding in the nature of an appeal available in respect of the relevant decision of a qualification body. And that was the question which was in issue, or the provision that was in issue in the General Medical Council against Mitchell Act, which is tab 45 of the authorities bundle. Page 1062 is where the authority begins. And the question that the Supreme Court was concerned with there was whether the particular proceedings available in respect of decision of the General Medical Council were proceedings in the nature of an appeal. So that was the issue in that case. But in the course of addressing that issue, at page 1067 of the bundle, paragraph 17 of the judgment of Lord Kerr, he notes and acknowledges the legitimacy of the aim that I've identified. So he says these considerations provide the backdrop to the proper interpretation of section 120, subsection 7. Part of the context, of course, is that appeals from decisions by qualification bodies other than to the Employment Tribunal are frequently available. It would obviously be undesirable that a parallel procedure in the Employment Tribunal should exist alongside such an appeal route, for there to be a proliferation of satellite litigation incurring unnecessary cost and delay. Where a statutory appeal is available, Employment Tribunals should be robust in striking out proceedings before them which are launched instead of those for which specific provision has been made. Employment Tribunals should also be prepared to examine critically at an early stage whether statutory appeals are available. Parliament plainly intended that section 127 would exclude jurisdiction for certain challenges against decisions of qualification bodies. The rationale for doing so is plain. Where Parliament has provided for an alternative route of challenge to a decision, either by appeal or through an appeal-like procedure, it makes sense for the appeal procedure to be confined to that statutory route, avoids the risk of expensive and time-consuming satellite proceedings, and provides convenience to the appellant and respondent alike. That rationale can only hold, however, where the alternative route of an appeal or review is capable of providing an equivalent means of redress. I'll come back to that final sentence in due course. But
I'm so sorry, it's my fault. Which paragraph are you reading from?
I just finished paragraph 18, so 17 and 18 were the two paragraphs.
17 and 18, thank you.
Right. So that's the second of the relevant purposes to be balanced. And then the third is the one that as I acknowledged to my Lord Justice Jackson, is the purpose of plainly the purpose of the Equality Act as a whole, which is to provide appropriate redress for discrimination in the spheres to which Parliament has decided that the Act should apply. It does not, however, in my submission, follow from that general purpose that achieving that aim necessarily entails access to an employment tribunal or indeed to the civil courts. And sticking with Mishlak for these purposes, if I may, it's worth also noting the discussion beginning at paragraph 24 on page 1069 of the authorities bundle of the earlier decision of the Court of Appeal in Khan and the General Medical Council. Lord Kerr says in that case, the appellant's application for full registration as a qualified medical practitioner had been refused by the GMC after a 5-year maximum period of limited registration. His application for full registration in accordance with section 25 of the Act was refused. He then applied to the Review Board for Overseas Qualified Practitioners for a review pursuant to section 29 of the Act. That application failed, as did a second application and request for review. He then made a complaint to the Industrial Tribunal, which the Industrial Tribunal found was excluded by reason of the equivalent provisions in the predecessor legislation, Race Relations Act, which looked to section 127. The appellant's appeal to the Court of Appeal was unsurprisingly dismissed. It was clear that his application to the Board Review Board constituted a proceeding in the nature of an appeal. Then Lord Kerr cites dicta of Lord Justice Hoffman, as he then was, in Khan. It is a short answer, a short question of construction, which in my judgment admits of an easy answer, namely yes. Section 29 of the Act of 1983 allows the decision of the General Medical Council to be reversed by a differently constituted set of persons. For present purposes, I think that is the essence of what is meant by proceedings in the nature of an appeal. And then at paragraph 26 of Michalak, it's worth noting how the proceedings that challenging the decision in Khan are described. It was because the review board could, by their recommendation made to the president of the GMC, effectively reverse the decision of the GMC that Lord Justice Hoffman considered the review was in the nature of an appeal. The review by the board was open-ended, and the decision that they were entitled to reach was unconstrained, not inhibited by the circumstance that the GMC had reached a particular decision. So it's worth noting, therefore, that this was an open-ended review, but the outcome was in the form of a recommendation to the president of the GMC, not a binding finding or conclusion. And then at paragraph 27, again with citing the dicta of Lord Justice Hoffman, it goes on, for my part, I do not see why an application for review under section 29 should not be regarded as an effective remedy against sex or race discrimination in the kind of case with which section 12.1 of the Race Relations Act deals. That concerns qualifications, professions or trades. Parliament appears to have thought that although the Industrial Tribunal is often called a specialist tribunal and has undoubted expertise in matters of sex and racial discrimination, its advantages in providing an effective remedy were outweighed by the even greater specialism in a particular field or trade or professional qualification of statutory tribunals such as the Review Board, since the Review Board undoubtedly has a duty to give effect to the provisions of section 12 of the Act of 1976. This seems to me a perfectly legitimate view for Parliament to have taken. So what you can take from Michalak is that it is, in meeting the third purpose that I've identified, the providing an appropriate means of redress, it is not a requirement that the means of redress be by way of Employment Tribunal proceedings. They may appropriately be by way of a different but equally specialist, in some instances more specialist, tribunal or body, provided of course they provide an effective means of redress of the kind that's outlined there, but that may include by way of recommendations made by the body rather than by binding decision. The next, so those are the three purposes that need to be balanced when considering all of the issues in this case, whether it's possible to read down whether Parliament has struck an appropriate balance. Let me then address the first of the two limits to read down under the Gaydon principles, that is that the read down would cut across a deliberate and fundamental feature of the legislation. And here, if it cuts across any of the deliberate and fundamental features, that will be sufficient for it to be an improper read down. It doesn't have to just be the overarching fundamental feature. The short point that I've already anticipated to some extent is that both when the 2010 Act was first enacted and when it was amended by primary legislation as part of the package of measures brought in 2015, the combined effect of the provisions that we're looking at, or their equivalents, was clear and apparent, and therefore it must be taken that Parliament has deliberately chosen to balance the three considerations I've identified in the way that those provisions envisage. So to deal with the position when the legislation was first enacted, first of all, you have the original version of section 121 at page 73 of the Authorities Bundle, tab 8. Page 73. And you'll see there that the terms of subsection 1 are the same as those that we're concerned with. The differences are in the provisions as what is treated as withdrawn or not withdrawn, and subsequent amendments to that. The relevant armed forces service complaints regime then in force was made pursuant to what was then section 334 of the Armed Forces Act 2006, which is at page 23, the Authorities Bundle, tab 4. And you will see that subsection 1 is in similar terms to subsections 1 and 2 of what is now section 340A. Come to that. So if a person subject to service law thinks himself wronged in any matter relating to his service, or a person who ceased to be subject to service law thinks himself wronged in any matter which occurred while he was so subject, he may make a complaint about that matter under this section, a service complaint. And then subsection 2, but a person may not make a service complaint about a matter of a description specified in regulation is made by the Secretary of State. So first point to observe is that at the time the Equality Act was first enacted, the primary legislation expressly envisaged that there may be some complaints that would be excluded from its scope. And turning then to what was excluded, in Regulation 4 of the 2007 regulations, page 57 of the Authorities Bundle, tab 6, a person may not make a service complaint about a decision of the Defence Council under section 334, 7 or 8. And without flipping backwards and forwards, the reference there is to page 24, and that is that 7 is the decision of Defence Council in relation to a service complaint, and 8 is the determination of remedy in relation to a service complaint. So the exclusion was narrower than the current exclusion. It didn't include all aspects of the service complaints process and decisions under it, but it did include the primary decisions of under the service complaints process and the determination of redress under the service complaints process. So it would still, in this case, exclude the claimant's victimisation claim, for instance, in relation to the decisions made under the service complaints process. And I've already observed in the structure of the legislations that there is no carve-out from that exclusion for discrimination claims about the conduct or aspect or about the outcome of service complaints, in contrast to the carve-out which applies in respect of the other excluded matters in the schedule, where paragraph 2 at page 62, read with regulation 9, permits complaints about, amongst other things, discrimination in relation to those other excluded matters. And so, looked at as a whole, first of all, the distinction between those other excluded matters and complaints about complaints is plainly deliberate. It's plainly deliberate that there should not be a right to make a service complaint of discrimination about the conduct, about the outcome of a service complaint, because no carve-out has been applied. And secondly, at the point the Equality Act was enacted, the effect of that in respect of section 121.1 was clear. It would necessarily mean that somebody who had a complaint of discrimination about the decision in their service complaint would not be able to make a service complaint about that, and would not therefore be able to bring a claim in the employment tribunals about that, because they would be excluded by section 121. So this was a clear feature at the point when the 2010 Act was first enacted. But if that by itself were not enough, when one comes to the 2015 scheme, that was enacted via a mixture, a package of primary and secondary legislation, in particular the Armed Forces Service Complaints and Financial Assistance Act 2015, which is at tab 10, beginning at page 93 of the bundle, and included at pages 115 to 116 amendments to the Equality Act, including section 121 itself, so as to reflect and bring it into line with the new procedure regulations, in particular in terms of treating what's to be treated as withdrawal or not. All had to be brought in line with the relevant procedure regulations. And alongside that, then the various new regulations brought into effect.
Sorry, you referred to the 2015 Act, which is
Yes.
pretty massive. We haven't looked at it. Is there any I'm not asking for a guided tour, but any particular section you
Yes,
were referring
on
to?
page 115 of the bundle, you'll see at section 12, part 9 of the Equality Act 2010 enforcement is amended as follows, and then section 13, within section 121 itself, substitute the following for subsection 2, and that was to bring the provisions as to what counts as withdrawal of a service complaint in line with the new regime. But the point I take from it is that Parliament was looking at section 121 itself, and by primary legislation amending section 121 to the extent it considered necessary in light of the new regime that's being brought into effect in 2015. And then at section 15 over the page, 116, you'll see there, it's the only place you've got it in the bundle, the definition of service complaint that's introduced for the purposes of the Equality Act at that point, which means a complaint under section 340A, 1 or 2 of the Armed Forces Act 2006.
Why does that definition not refer to subsections 3 and 4 of section 3.4 capital A?
In my submission, simply because it's subsections 1 and 2 that are the provisions pursuant to which a service complaint may be brought, and then the effect of 3 and 4 is to restrict when somebody may bring a complaint under subsections 1 and 2. But it's not necessary to refer to 3 and 4 because the exclusionary effect is inherent. So the central point I make for present purposes is simply that this was primary legislation as part of a package of measures which included the secondary legislation regulations we're concerned with, introduced in 2015, where Parliament has expressly considered the interrelationship of this whole scheme and how section 121 will interrelate, And again, the exclusionary effect is clear. Pursuant to the miscellaneous provisions, Regulation 3 now, at page 143 of the bundle tab 12, you have the same, essentially the same structure as previously. So subparagraph 1 of Regulation 3, page 143, excludes matters in the schedule, and then when one goes to the schedule, paragraph 1 at pages 146 and 7 has that long list, and then paragraph 2 at page 148 excludes from the exception, or accepts from the exclusion, put it, matters falling within Regulation 5.2, which in turn includes matters that amount to discrimination. That's page 144. So in respect of that long list of other potential avenues for redress that are excluded from the service complaints process, the effect is that if your complaint is that in relation to a complaint under the internal disputes resolution procedures of the Pensions Act 1995, I'm reading from paragraph 1A at page 146, if you wish to say, in relation to this matter which I could complain to under the Pensions Act, my complaint is one of discrimination, then you can bring a service complaint about it and then proceed to the tribunal in relation to it. But that exclusion doesn't apply to the exclusion of complaints about the conduct or outcome of service complaints under subsection 2 of Regulation 3. So again, Parliament has deliberately decided there should be no complaints of discrimination, no service complaints of discrimination about the conduct or outcome of service.
Well, when you say Parliament, it's what's the procedure for making these regulations? Is it negative or positive resolution procedure?
It is. I'm afraid I don't have that.
Oh well, don't worry. I mean, if you
but
just
Is
let me know.
it on page 142?
Not laid before Parliament.
Yeah.
Not laid before Parliament.
Sorry?
Not laid before Parliament.
Approved by.
Were laid before and approved by.
Yes.
Yeah.
Laid before and approved by
Yeah.
resolution.
There it is. Positive resolution.
Yeah, so it's a positive resolution.
It's positive resolution.
Yeah.
So essentially, I'm sure there's more, but what I take from this, you're saying that in 2006, Parliament set up a system whereby there were exclusions.
Yes.
In 2010, it revisited it with the making of the Equality Act
Yes.
and made further provision.
Yes.
And it made still further provision in 2015. So
Yes.
within a decade,
Yes.
Parliament looked at this 3 times.
Yes.
And in each case, whatever the merits of it, it was perfectly clear what was and wasn't permitted.
Yes. That's the long and the short of it, and there isn't more to say than that. Really, so the effect is Parliament must be taken to have intended and understood as a deliberate feature of the overall package of measures that the particular exclusionary effect we're concerned with was the appropriate balance of the 3 competing considerations that I identified, and in particular was the appropriate way of limiting satellite challenges to the service complaints process, both internally and externally.
I'm just looking at this last paragraph. I'm just trying to get my head around it. This is paragraph 2 of the schedule.
Yes.
So you make, let's take 1F. You allege allege that you're the victim of criminal injury overseas and you apply for a payment and you're turned down, you appeal to a service appeals panel
Yes.
under that scheme.
Well, you apply and you're turned down under that scheme. If your complaint is the person who has turned me down has reached an irrational conclusion, then you cannot make a service complaint about that. Your only means of redress is by way of appeal to the Criminal Injuries Compensation Overseas Scheme. Hello.
Yes.
If you wish to say the person who has turned me down has done so because I am gay, then that falls within paragraph 2, so it's accepted from the exclusion, and you can make a service complaint about that matter.
Yeah.
And then
That's not Russian dolls. That's the first body could not have dealt with your allegation of discrimination.
yeah.
But why is any of this helpful in deciding whether the exclusion of going to an employment tribunal about what the service complaint panel did, whether that exclusion is deliberate?
Because all of the effects are clear, as are the relevant considerations or purposes to be balanced. And so the proper conclusion to reach, the inference to be drawn, is that Parliament has deliberately intended that effect as the proper balance of those three considerations. So it's decided that in the case of a complaint about the conduct or outcome of a service complaint, there should be a single route through in all cases, whether about discrimination or otherwise. And the single route through is service complaint, appeal, and if you don't like the way that's been done, off to the Ombudsman. That's the single route through. It avoids the Russian dolls, but it also avoids the satellite litigation that at the same time as the Ombudsman potentially deciding discrimination by the service complaints decision makers, you may also end up with employment tribunals deciding that same thing. So for the moment I'm not as it were, making submissions about whether this is a good or bad choice by Parliament. In fact, I'm proceeding for the present purposes on the assumption that you will have found a breach. But my point is that this is what Parliament plainly has decided deliberately should be, the relevant balance of considerations in this case, in this instance. So, for those reasons, and
that's sort of, sorry to interrupt. This is just a point that occurred to me. So that the idea that Parliament has thought about this whole thing together is reinforced by the enactment of the 2015 Act, which specifically amends the Equality Act, and the whole thing was brought in as a package.
yes,
That's
precisely.
the point.
These are not two distinct regimes where the effect can be seen to have happened by accident without anyone really thinking about how they're interacting. It's clear that Parliament has thought about how the two interact. So that's the first. That brings me to my first conclusion on the limits of read down in this case. That is a fundamental feature of the legislation, and it would therefore be contrary to that limit to read it down in that way. But there's a more focused aspect to that as well, which is that it's common ground that it is a fundamental feature of Section 121 itself that before bringing any claim to an employment tribunal, by a service person, they must first have raised a service complaint. And so, on any view, the claimant's proposed read down, the one adopted by the Employment Tribunal, would cut across that fundamental feature of Section 121, because the effect of her proposed read down would be to enable a complainant who wishes to allege discrimination in the conduct or outcome of a service complaint to bring a claim in the tribunal without first raising it through the internal process in any way.
But Rick, I would understand that better if it was the old wording from 2006 that to establish employment tribunal jurisdiction, the complainant must have made a service complaint and, as it were, seen it through to a determination. But I don't understand the logic of unless the complainant has made a service complaint and it hasn't been withdrawn, and that you can do the two on successive days. What's the point of that?
Well, you have to make it and not withdraw it. So the point about not withdrawing it is you then have to pursue it. As my Lord Justice Jackson observed, if you don't pursue it, you may be treated as having withdrawn it.
No, but you do. At this stage, all you've done is lodged it with the complaints body, and the next day you file an ET1. You haven't, by doing that, withdrawn the service complaint and say, I want the two to run in parallel.
No, but if you then fail, if you then withdraw, including implicitly withdraw by failing to pursue your service complaint, then the jurisdiction of the tribunal may be removed by that failure. So,
supposing you don't.
So the statutory, but precisely the statutory purpose of giving the armed forces an opportunity to address the allegation is fulfilled, and that is the statutory purpose of Section 121. That otherwise it really serves no purpose at all. And again, for these purposes, whether or not that's a good purpose or not is not for this court to say. Parliament has decided that before you can bring a claim in the tribunals, you need to have made a service complaint first. And that is absolutely fundamental to Section 121. And it's common ground that the objective of doing so is to enable the armed forces to have an opportunity to consider and redress your complaint. The claimant's proposed read down would have the effect that somebody in her position could bring her claim to the Employment Tribunal without ever raising it in any service complaint context or giving the armed forces an opportunity to address that complaint first. And so it would cut across, directly across, that fundamental purpose of Section 121 in these cases. So, my lady, my lords, those are my submissions on the first limit of read down. The second limit of read down is where there are multiple options for resolving any breach, which raise questions of policy, calling for legislative deliberation. For the purposes, again, of this issue, I'm proceeding on the assumption that the exclusion of tribunal claims for discrimination in relation to the conduct or outcome of service complaints breaches Articles 6 and 14 of the ECHR, but that there is nothing objectionable about the general effect of Section 121 of requiring a service complaint to be brought first and not withdrawn. And so what rectifying the breach would require would be to enable someone who wishes to complain about discrimination in the conduct or outcome of a service complaint to bring that complaint in an employment tribunal, but may require them to raise it through another process, such as the service complaints process, first. On that basis, and between the parties and the Ombudsman, there are at least 3 options which have been identified which would remedy that breach. I'm going to go through each of them in turn and show you how each of them would differently balance the 3 competing objectives that I've identified. So the first option is the claimant's proposed read down. And we can take that from the Employment Tribunal's decision at page 133, paragraph 89, the core bundle. Mr. Nelson says the precise wording doesn't matter and now prefers the employment judge's proposed wording, but also would be obviously content with his own. So the employment judge's proposed wording, it would be to read the words in where the complainant is entitled to do so. Page 133. Read the words where the complainant is entitled to do so within the start of section 121. So that would have the effect that where there is no entitlement to bring a service complaint, the exclusionary effect of section 121 doesn't apply, and then there's the alternative set out in italics proposed by Mr. Milson. So the effect of that proposed read down would be that in a case where the claim is about discrimination in the conduct or outcome of a service complaint, a service person could bring a claim, full stop. The normal jurisdiction of the tribunal would apply without any requirement to raise that matter at any stage of the service complaints process or ombudsman process. So it would undoubtedly meet the third of the objectives that I identified. It would confer a jurisdiction on the tribunal which everyone accepts is an appropriate means of redress. But it would fail to meet either of the other 2 objectives that I identified. It would not give the armed forces any opportunity to address the matter through the service complaints process. And it would not minimise the scope for collateral challenges to the service complaints process in the way that Parliament has intended. And we respectfully therefore endorse what the Ombudsman says at paragraph 22 of her submissions, page 258 of the bundle, that the claimant's proposed read down is inconsistent with the underlying thrust of section 121(7). The second option that is presented in the material before the court is the proposed read down on behalf of the Ombudsman, and that's at paragraph 24 of the Ombudsman submissions, same page, page 258 of the bundle, which is to give the term service complaint in section 121 an expansive construction which would be broader than the express definition that I took the court to in section 141 of the Act. That is, that it could include an appeal against a decision body's decision on a service complaint and an application to the Ombudsman. So just to explain what I understand the Ombudsman to be indicating as the solution which resolves any breach there. The effect would be, if somebody wishes to complain about discrimination by the first instance decision-making body in the service complaints process, say they've victimised me in their decision, as the claimant does in this case, then you would read the requirement in section 121 to make and not withdraw a service complaint as including raising the matter through an appeal within the service complaints process. So the requirement on the individual would be to raise that matter as part of their appeal under the service complaints process and then not withdraw it. But the Ombudsman has to go further in order to meet the objective here, assumed objective of ensuring the tribunal can ultimately have a jurisdiction. You have to go further, because if the alleged discrimination in the service complaints process were by the appeal body, say it's alleged that the appeal body made a decision that amounts to victimisation, there's no more of the service complaints process left. And so that's why the Ombudsman is saying you also read service complaint to include application to the Ombudsman, because then what the Ombudsman is saying, what the individual would have to do is complain to the Ombudsman about the conduct of the appeal body, and that would be treated as a service complaint, and provided it's not withdrawn, then the tribunal would have jurisdiction on that reading under section 121(1). But the problem with all of that is that you end up then in a position where, for some of these complaints, where the alleged discrimination is by the service complaints appeal body, you end up in the position where the individual is obliged to make use of two separate external challenges to that process if they want to proceed in the tribunal. So in the ordinary case, the individual has to bring a service complaint and then has a choice if they're not happy. They say they've been discriminated against by their commanding officer outside the service complaints process. They have to bring a service complaint about that. They're not happy with the outcome of the service complaint. They then have a choice to proceed with the tribunal or the Ombudsman or both or neither. But in this instance, on this reading, you would end up in a position where they wish to complain about discrimination by the service complaints appeal body. If they want to go to the tribunal, they have to also go to the Ombudsman. And so that very definitely undercuts the objective of limiting collateral and satellite litigation, because you have to have multiple satellite complaints and processes.
There's another layer though, because if you were alleging discrimination in the original decision on your complaint,
Yes.
essentially it works, as I understand it, you then have to appeal against that.
Yes.
And you then, when you're dissatisfied with the appeal, have to go to the Ombudsman.
Yes.
It's going to take forever.
It is. So this proposed read down, again, it achieves the objective of conferring a jurisdiction on the tribunal, which everyone accepts is an appropriate way of meeting the third objective identified, but it certainly undercuts the objective of minimising collateral and satellite litigation challenges to the service complaints process.
I'm not sure how it works with the time limits for the tribunal. Don't you have to put in your complaint against the discrimination or victimisation or whatever it is? Don't you have to put that in what, 3 months?
Yes. So it's
So how does that fit?
well.
I know it's not your proposal, but
No, I mean, as my Lord identifies, my point is that you end up effectively legislating from the bench here with a completely new regime that has obvious disadvantages and downsides policy-wise. And, you know, maybe having thought about it all carefully, that would be the solution that might be adopted. But I would be very surprised, and my central submission is it's certainly not something that it's appropriate for the court to decide about. But that's a realistic option put forward by the Ombudsman of a way of resolving this and balancing those various competing outcomes differently. A third potential solution, which is one that we identify in paragraph 65 of our skeleton argument, page 232, is that you could, in effect, read a similar exclusion, or add into the 2015 regulations a similar exclusion to the one that applies to the other routes for challenge, the other excluded matters. So you could say, in respect, where your complaint about the conduct or outcome of a service complaint is one of discrimination or other breach of the Equality Act, then you can bring a service complaint about that, and then everything else follows. The tribunal would have jurisdiction. So that would again achieve the objective of conferring an ultimate jurisdiction on the tribunal. It would also achieve the objective of section 121 of requiring any alleged discrimination to be raised through the service complaints process before the tribunal has jurisdiction, but it would hold up the spectre of the Russian dolls that my lord identified. So it would not meet the objective of avoiding repeat complaints or repeat internal challenges under the process. So what I hope I've illustrated by this is that there are practical policy consequences of all of the potential read-downs that one might adopt, which have different implications for each of the three policy considerations that I began by identifying. And par excellence, balancing those policy considerations on the assumption here that one ultimately has to confer a jurisdiction on the tribunal, balancing those policy considerations is par excellence a matter of legislative policy choice for Parliament, and not for this court to decide between those various options.
I'm sorry, whose suggestion was the last one? That you go through service complaint, appeal, ombudsman, then another service complaint, and then the EET.
No, the last suggestion is not one I'm positively advancing.
No, of course you're not.
It's our identification of a further option. Right. So the further option would be to treat service complaints in the same way as the other excluded matters under Regulation 3. And the proof of the pudding, if I may say so, is in the eating. I sought instructions as to whether I might be in a position to say to this court, if you find against us on breach, this is the preferred option. And the answer has come back. If that were the case, we would need to study very carefully the court's decision on breach. There would need to be an evidence-based analysis done of the potential implications of all the possible solutions that would ultimately confer jurisdiction on the tribunal within the scope of the service complaints regime. That would need to be escalated to ministers in the Ministry of Defence. It would also need to get the sign-off from ministers in the Government Equalities Office who have conduct of matters relating to the Equality Act 2010, and it would then ultimately be for Parliament to decide through either primary legislation or the relevant procedures for secondary legislation what the appropriate solution should be. And so the suggestion on behalf of this claimant that this court can decide that her preferred read-down conferring automatic jurisdiction in these cases is the right one simply will not fly. This is absolutely a case where there are several options available with different implications for important policy considerations, and if there is a breach, that would have to be a matter that would go back to Parliament. But and this.
Yeah. Well, Lord Justice Peter Jackson has said something about the point I was about to put to you. You have spent the last hour and a half on what the possible solutions are if you lose the appeal. You haven't so far said why you shouldn't lose the appeal. And can I flag up that we must finish by 4:30?
Yes.
On what may? Right.
I'm grateful, my lord. I was about to turn to that with the remark that I hope it's been a useful exercise to approach it from that end of the telescope, precisely because what I hoped to show by presenting the different options and the way the policy considerations have been balanced is that this really is a question of Parliament exercising within its margin of appreciation its obligation to balance these different interests, and that is of high relevance when one then turns to the question of justification, which is the only question that arises in relation to
Yes.
Article 14, read with Article 6. Can I just address the applicable test first of all? In my submission, the relevant principles are these. The test is, firstly, whether the difference in treatment pursues a legitimate aim, and secondly, whether there is a reasonable relationship of proportionality between the aim and the means used to achieve it. It is not necessary or appropriate to go through the full rigours of the 4-stage Bank-Mallet test. And in applying the test I have identified, the court must apply an appropriate margin of appreciation, which in this case is a wide margin, the boundaries of which are properly described as being whether the solution Parliament has adopted is manifestly without reasonable foundation. In view of the time, I hope the court will forgive me if I don't turn up all of the authorities but give references for those propositions and the points that I take from them, and please do say if you'd like me to go to any of them as I go. There are really 3 authorities which support those propositions that I've set out. The first is the Crown Carson against the Secretary of State for Work and Pensions, which is tab 31 of the authorities bundle. Paragraphs 14 to 17 of the speech of Lord Hoffman, pages 716 to 7 of the bundle, you will see that he there identifies that discrimination on the basis of core characteristics under section 14, what are described as suspect characteristics in the US context, requires substantial justification, whereas discrimination on non-core grounds may merely require some rational justification. And similarly at paragraphs 55 to 58, pages 725 to 6, Lord Walker draws a similar distinction, suggesting at paragraph 58 that where it's a non-core characteristic, the standard is whether the distinction is devoid of any rational basis. I would also highlight in particular paragraph 56 of the speech of Lord Walker, in which he's quoting the US Supreme Court. This is a point that I'm going to pick up in the other authorities as well, emphasising that the drawing of lines which create distinctions is a peculiarly legislative task and an unavoidable one. Perfection in making the necessary classifications is neither possible nor necessary. The second authority is the Crown SC against the Secretary of State for Work and Pensions. It's tab 54, the authorities. and at paragraph 98, page 1432 of the bundle in particular, you will find Lord Reid making clear that the relevant test is the two-part test I began by outlining. Whether there's an objective and reasonable justification is to be judged by whether there's a legitimate aim and a reasonable relationship of proportionality. Paragraphs that I invite the court's attention to, in particular, are paragraphs 100, 114 to 15, 129, and 160 to 162, all Lord Reid, all in Lord Reid's judgment. And he is there, again, emphasising that although there are a number of factors that may be relevant to the breadth of the margin of appreciation, the nature of the ground, whether it's a core ground or a non-core ground, is of central importance. And I would also highlight in particular paragraph 162, where he again notes that all legislation will differentiate, and so where there is a wide margin applicable, courts should be slow to encroach on the role of Parliament in drawing distinctions simply because they're not perfect or produce some anomaly. That's my gloss, not his precise words. It's also made clear in that case that, I should just double check the correct reference for this. Paragraph 160, the manifest, and 161, the manifestly without reasonable foundation formulation is recognised as being an appropriate description of the margin of appreciation in cases where there is a wide margin to be applied, albeit that it should be understood as a description of the margin rather than as a test in and of itself. And the last of the authorities is Sullivan and Isle of Wight's decision of this court at tab 63 of the authorities bundle, in particular paragraphs 74 to 81 and 98 to 99 or 98 to 101 in the judgment of Lord Justice Lewis, effectively endorsing and explaining the effect of the Supreme Court's decision in SC, again at paragraph 81, reminding us that all legislation involves differentiating between different groups, and perfection is not possible, and at paragraph 99 and 101, making the second of the points that I did, that the full rigours of the bank Mellap test are not necessary or appropriate in a case of this kind under Article 14, and that the two-part test is the correct one. So in my submission, what those authorities establish very clearly is that where, as here, the ground is a non-suspect ground, a wide margin applies, and the test is therefore, in effect, the manifestly without reasonable foundation test. I don't propose to take up further time now going through the points that we make in paragraph 53 of our skeleton, page 227 of the core bundle, which distinguish this case from the case of Gillam, upon which Mr. Milsom placed some reliance. The short points in that regard, if I can summarise them in this way, are that what Baroness Hale said in Gillam about a narrower margin sometimes applying in the case of employment or social policy was plainly obiter, because the actual decision in that case was based on the fact that no legitimate aim had even been advanced, and so the question of the margin of appreciation didn't even arise. Secondly, those remarks were based on the Supreme Court's decision in Re G, which has since been expressly disapproved in Elan Kane. We've given the references in that paragraph. And thirdly, that suggestion is contrary to the clear and binding authority of SC, which is, and indeed Elan Kane, which is more recent than Gillam, to the effect that where there's a non-suspect ground, a wide margin will generally apply. So that's the nature of the test that applies, and really the only question, therefore, is whether there is a rational connection between the difference in treatment and the relevant objectives. My central submission in that regard is that there is no solution which perfectly achieves all three of the objectives that I began by identifying in my oral submissions. Any solution involves striking a balance between them and thereby compromising one or more of them to some extent. As the authorities recognise, drawing imperfect distinctions in that regard is often inherent in the exercise of legislating and is certainly a matter for Parliament. And in this instance, the balance which Parliament has struck is one which is well within its margin of appreciation. So I don't argue, and I don't need to argue, that the combined effect perfectly achieves all of the objectives that I've identified, or that there are no anomalies at all. What I do argue, and all that I need to argue, is that it strikes a reasonable and rational balance between the competing objectives. So, as to the objective of limiting collateral challenge to the service complaints process and decisions, what the exclusion does, as I described earlier, is exclude all direct challenges to the service complaints process itself. So it therefore excludes the prospect of the Russian dolls, but it also excludes the possibility of all direct claims of discrimination in respect of that process, and provides a single finite route for pursuing all complaints about service complaints process, including discrimination complaints about that process, through the Ombudsman route ultimately. That is a legitimate objective in the interests of preserving morale and discipline, as the EAT observed at paragraph 72, pages 72 and 73 of the bundle. That's a matter of common sense. If you have protracted complaints about service complaints and tribunal claims alongside ombudsman claims in relation to those matters, all by serving members of the armed forces who need to maintain their relationships and pursue morale or have high morale and high discipline, then you will inevitably undermine those objectives if you permit all of those collateral challenges and Russian doll challenges. I accept that this does enable one external challenge to the service complaints process. So it's not trying to exclude all external challenges. The Ombudsman does provide a route for that external challenge, and that's how Parliament has balanced the need for some form of redress against the need to limit the scope for challenge. I also accept that this solution still enables indirect external or collateral challenges to the service complaints process. So if you've complained about discrimination by your commanding officer and you go through the service complaints process, you can then present a claim to the tribunal which may indirectly question the way that it's been resolved or not resolved through the service complaints process. But what it does is it stops that direct challenge to the conduct and decision making under the service complaints process itself. I also accept that drawing the line at some point in relation to current versus former service personnel will inevitably produce what look like some anomalous results. It does mean, wherever you draw the line, that a meeting held under the service complaints process that happens the day before is something that will fall within the exclusion, and a meeting under the process that's held the day after discharge will not fall within the exclusion.
Why, you've several times referred to anomaly when it might equally be described as a difference.
Yes.
I mean, why is it anomalous that one position is taken in relation to a serving person and a different position is taken somebody who's not serving?
Precisely.
Why would you accept that was an anomaly?
I was accepting that it could be characterised as anomaly, but I adopt my lord's point that my submission is it's not an anomaly. It's a necessary consequence of drawing these distinctions. There is an obvious rational distinction that if somebody has left the armed forces, it doesn't matter so much how much challenge can be made to the process. So there's an obvious rational distinction. Drawing the line anywhere will produce differences, but it's for Parliament to decide where that line should be drawn.
Do civilian employees, serving employees, have access to the service complaints process?
No.
No. So they are, and that's an obvious distinction,
Yes.
I would say. It's not an anomaly, it's just a different system.
Yes.
How you, people who have left, retired, resigned, gone on to do something else, have become civilians again, whether you classify them with the serving officers or with the civilians, you would say, well, that's a matter of judgment. But could have been done one way, it could have been done the other way, but it's not manifestly without reasonable foundation, if that's the test.
Precisely that, yes.
Because all the considerations about morale and discipline no longer apply by definition if you've left.
Exactly that, yeah.
Yeah.
And if I could just deal with a couple of points upon which Mr. Milson placed some emphasis. First of all, the suggestion at paragraph 53(1) of his skeleton argument that the exclusionary effect we're talking about necessarily excludes claims by someone affected by a service complaints process who isn't the actual complainant. He accepts, I think, that so far as maladministration is concerned, that's not the case. That somebody who is, let's say, racially abused in the course of a service complaints process and isn't the complainant can make a separate service complaint about that, because the exclusion is limited to maladministration in relation to his service complaint. The same, in my submission, the same limitation obviously applies, giving a sensible meaning to the exclusion and the terms used, to all of the other exclusions. That the exclusion in respect of a decision under the service complaints process must obviously mean a decision in respect of the complaint of that particular individual, not the decision in respect of somebody else's complaint that has some bearing on a particular individual. But in any event, that is not this case. And if that were to arise in a future case, that would be something to be grappled with at that stage. The short point for present purposes is that the interpretation is not obvious and inevitable. And if there were, in a future case, a question about whether the effect of somebody else's service complaints process on a third party is discriminatory, that's a matter to be addressed by reference to the particular circumstances of that future case.
I was troubled by an example that Mr. Milson gave, but I hope I've understood it correctly, that a service complaint, I don't know how often this happens, but a service complaint can be made by a more senior officer against a more junior officer. officer or non-commissioned officer. And if that is done with malign motives, what remedy does the junior, the cadet, have?
Well, there would be nothing to stop the junior making a service complaint saying that this individual has,
Colonel Whatnot. Yes.
has made a service complaint against me because of my race.
Yes.
That, on any view, nothing in Regulation 3 of the Miscellaneous Provisions Regulations.
Where is the definition again about what is a complaint? Because it's something you suffered a wrong.
Yes, it's section 340A, page 36 of the Authorities Bundle.
Thank you.
Person subject to service law thinks himself or herself wronged in any matter relating to his or her service.
Well,
Person may make.
it becomes quite hard to see how the general is wronged by the cadet.
No, but the cadet may be wronged by the general and may complain about the.
No, but if you're I myself noted, I think it was Mr. Wilson's point 6 or something like this, about a situation where the boot was on the other foot and
Yes.
the cadet was being complained about.
Yes.
But I'm just wondering how that fits with the definition of a complaint, and whether it runs.
I think it would run. Let's say a cadet racially abuses a general. The general would, I think, be entitled to bring a service complaint about
Right,
that.
so it wouldn't be so much in the nature of victimisation or anything. That's what it
No,
is.
no. But one could. Again, I don't know how much.
You could think of it. You could think of some odd
Yes.
instance.
Yes. But if the cadet then wishes to say.
Yes. But you wouldn't think that if a cadet racially abused a general that it would end up as a complaint.
You'd think there'd be other.
You think
Other
there'd be
solutions.
other ways of dealing with that.
Route, but, yeah.
Yeah.
All right.
But my short point in relation to all of that is it's holding up a spectre of some dreadful consequence which doesn't necessarily follow from the statutory wording and is best thought about in the context of an actual claim where the issue arises, not this case, and as a matter of the general principle of balancing these considerations, it doesn't really take matters any further. And similarly as to my submission, highly improbable and narrow circumstance where theoretically there's a course of discriminatory conduct preceding and leading up to a service complaint, and then further discrimination happens in the service complaint, which is the final straw that prompts the individual to leave. Again, one can see immediately fairly obvious ways in which a tribunal dealing with the whole course of conduct up to but not including the discrimination in the service complaint would be able to consider an overall sensible remedy in that regard. And moreover, as I'm about to come to, the course of redress of the Ombudsman is still available to that individual.
But also, if you've got a course of conduct leading to a final straw, would it be possible to bring an unfair dismissal claim?
It wouldn't, because armed forces personnel don't have contracts of
have
employment, and they're not deemed to have
Oh, of course,
unfair
yeah,
dismissal
sorry, yeah, okay.
law so there's no wrongful dismissal or unfair dismissal claim. But it's a highly hypothetical, improbable scenario, which again would be best considered in the particular facts. It doesn't really help us with considering the broad principles that are relevant to this case. So the last point to make, therefore, in respect of justification is a proportionality point, which is to highlight again that we are dealing with a very limited category of case caught by this appeal. In addition to that, and in my submission as the EAT was right to observe, the availability of redress via the Ombudsman does ameliorate to a very significant extent the disadvantage of not having the right to proceed to an employment tribunal in this very limited category of case. I perhaps just make this observation in relation to the implications for the Ombudsman. She has told you via her submissions made by Mr. Halliday on her behalf that she does not have a practice of conducting oral hearings in public, and that she has resource issues. However, Parliament has conferred a whole suite of powers on her, and has expressly provided that the process that she follows should be appropriate to the circumstances of the particular case. Now, if you are with me, the effect will be that in this very limited category of case, and there's nothing to suggest that there are large numbers of these cases that are likely to have a significant resource impact. The effect will be that in this very limited category of case, the Ombudsman will be the sole source of redress for alleged discrimination in respect of the conduct or outcome of service complaints. And it may therefore be that a consequence of this will be that it will be more appropriate for the Ombudsman in those cases to make use of the wide powers that have been conferred on her, and in due course will be conferred on the Armed Forces Commissioner, in order to provide something as close as possible to a court proceeding. And I'd just highlight very briefly in that regard at page 260 of the Authorities Bundle, tab 21, in the case of the Crown against the Department of Health ex parte Gandhi, that the Court of Appeal in that case, which I should perhaps just go to the headings and identify the issues, that at page 249, that was a case of an application to the Medical Practices Committee, where the individual wished to challenge alleged discrimination in respect of that in an appeal to the Secretary of State. The Secretary of State determined it without an oral hearing, and the Court of Appeal held that the Secretary of State ought to have held an oral hearing, having the power to do so in that case. And if I pick it up at page 259, just above letter H, Lord Justice Taylor says, "I accept that some appeals to the Secretary of State where race or sex discrimination is alleged may well require an oral hearing. Whether it's required in any particular instance will turn upon the facts of the case, in particular the allegations made, whether there appear to be other obvious grounds for the decision, and whether there are significant conflicts of evidence. Far from accepting wherever there is a claim of race discrimination, oral hearing is obligatory." And then over the page at 260, letter D, "I would emphasise that administrative convenience should not be allowed to override the exigencies of a particular case. An oral hearing should be held where, in the circumstances, the issues cannot fairly be resolved otherwise." So just to emphasise that sort of...
It's a divisional court rather than Court of Appeal.
I apologise, yes it is, it's a divisional court. So the proposition that I draw from that is that whilst I accept that the Ombudsman is not a full court, if I'm right about the Ombudsman being the appropriate form of redress in cases in this limited category, in those cases, the Ombudsman ought generally to exercise her powers to determine them as closely as possible to the way that an employment tribunal would. And to emphasise what those powers are, again, I'll give references rather than going through all of the labyrinth of the provisions, if I may.
Mr. Cooper, I'm concerned about the time.
Mm-hmm.
Yes.
That's real time now.
Yes.
Tarek has corrected the clock. We haven't heard Mr. Milsom in reply.
No.
We're pushing up against the limits of a one-day hearing. Are these provisions on these authorities on the power of the Ombudsman in appropriate circumstances to hold an oral hearing really going to help us?
Well, only to the extent that they show that what the Ombudsman can do, and I'll just run through it briefly and refer you to our skeleton argument where we've set out the nature of the Ombudsman's powers in detail.
Well, this is can do, but hasn't done since 2015.
No, but
Has never done.
has never done, but can do and ought
And
to
also
do.
the Ombudsman, I mean, a very full report I was just looking at now, 40, 50 pages. But it's distinctly not to be published.
Well, again,
It has a firm warning on the front saying that this is just for the individuals concerned.
yes. So, but I mean, I'll just very briefly run through it. So she hasn't done, but she can do in an appropriate case, and in my submission, could do in these cases. So she can hold an oral hearing. She can hold an oral hearing in public. She can decide not to impose confidentiality restrictions on the decision that she sends to the parties, and she can exercise the same powers in respect of disclosure and provision of information as the High Court. So, and failure to cooperate or interference is a contempt of court. So, in all those respects, she can conduct a hearing and give a public decision if that is appropriate in the particular circumstances. And I put it no higher than that. But what it does illustrate is that, again, Parliament has decided on the appropriate balance in all these respects, and so far as proportionality is concerned, has provided a means of redress which may, in an appropriate case, have all of those features to it, even if it doesn't and won't in all of those cases.
And if the Ombudsman refused irrationally to hold an oral hearing or do the other things, the Ombudsman's amenable to jail.
She is, and in the Hahn case cited in Mishlak, that was held to be an additional feature illustrating the overall effectiveness of the remedy in that particular instance.
Yeah.
So, my lords, my lady, those are my submissions on all the substantive issues. I think you will have gathered from what I said in opening and the way I've developed the arguments what the position is on the Declaration of Incompatibility. Section 120 is the primary legislation concerned, and the Declaration of Incompatibility can only be issued in respect of primary legislation. Section 120 by itself, 121, by itself is not incompatible with any of the ECHR rights. It's only the combined effect, and so given the limits on this court's ability to issue a declaration of incompatibility or to disapply secondary legislation, if you find there is a breach, but you are with me that you can't read down the legislation in any of the various ways, the appropriate course is simply to say that in your judgment with reasons, and it will then be for the Secretary of State and Parliament to decide how to proceed.
Yeah.
Would the court give me 1 moment? Just one point I ought to correct in case it got missed, which is that time limits for the armed forces are 6 months, not 3 months under the Equality Act. Right. But other than that, unless your lordships or your ladyship have any more questions for me, those are my submissions.
Thank you. Mr. Chigwilly? Mr. Milson?
Yes, my lady and my lords. It is of note in my submission that over the course of the appellate process, the scope of the defence to the substantive challenge on convention rights has narrowed, and my learned friend has devoted the majority of his submissions on disposal rather than appeal. Claimant would ask the court to draw the appropriate inferences on that. On matters of principle, there is no authority that suggests bank mallet is disapplied in an Article 14 case, cannot be, of course, in an Article 6 case, nor that is it the ratio of SC that where there's a non-suspect ground, there is a wide margin to be afforded. The claimant accepts that the drawing of lines is a job for Parliament, but there needs to be some evidence of a conscious decision of that And the line has to be at least intelligible. So in Sullivan, it was perfectly clear why job applicants are treated differently to employees. It is not remotely clear in my submission why some service personnel are better protected than others by reference to the happenstance of when the contravention took place. And you have my submissions on the Rees-Harper characterisation of that temporal bar, arbitrary, capricious, irrational, etc. I note the respondent's position, and it's to be welcomed, that the determination of these issues are to be by reference of substance rather than the decisions below. This is the first known case as well to reach this court where the service complaints regime has been determined on its merits. Therefore, in my submission, it's not appropriate to say that the hard cases, such as the deemed constructive dismissal, and as to that, my lady, section 39(7), page 79, because of the deeming provisions under section 83, would apply to the armed forces scenario as well. There's not a contract, but nonetheless a deemed constructive dismissal.
Right.
To defer that hard case, nor the hard cases on the position of the wronged cadet officer, who is at the receiving end of a service complaints regime, to a hypothetical date to be decided. What has to be justified in this case is the blanket exemption of access to the ET in any scenario where the discrimination takes place within the sphere of the service complaint. And it should not be presumed that the scope of that is narrow. I'm aware of at least 2 cases stayed pending this appeal, and the scope of the determination is important. In my submission, nothing you've heard addresses the points of substance on the scope of the exemption, nor the justification for it. On construction, the claimant agrees with the approach suggested by my Lord Justice Jackson. When discerning purpose, one looks first at the statute at large. So the purpose of the Equality Act is, of course, to eliminate discrimination in the identified spheres and give effect to the then prevailing obligations under EU law. Subject to the qualifier in section 121, which is the opportunity to rectify internally to the extent established in parallel statute and regulation. And if I may emphasise certain features on the wording and effect of section 121 that have emerged during the course of Leonard Friend's submissions. It's an opportunity, no more, no less. And what the 2015 regulations establish is that if the response to that opportunity is further acts of discrimination or harassment, or acts of discrimination and harassment that take place for the first time in the service complaint process itself. The 2015 regulations have made clear that the appetite to redress that discrimination is not open-ended and limited. So be it. And one can see that not every category caught by that exemption is within the Russian doll analogy. Discrimination may arise for the first time. And I'm afraid Mr. Cooper is right to say once the opportunity has been afforded, the statutory purpose is fulfilled. If that's right, the question which respectfully he has not answered is why are the armed forces therefore entitled to continue act as gatekeeper on access to an independent and public tribunal, whether by way of internal decision making or by way of subordinate legislation. It's neither legitimate nor a fundamental feature of the scheme. Secondly, withdrawal. There was some discussion on what's meant by withdrawal. Withdrawal is defined in section 121(2) itself. There is nothing there that suggests that the failure to cooperate is a deemed withdrawal. Maybe grounds perhaps for some measure of disciplinary action or some other form of legitimate response. But there is nothing on the face of the withdrawal definition in subsection 2 which requires wholehearted engagement, and nor is an ombudsman referral required at all, save in the wholly exceptional circumstances identified in section 121(2)(b. Contrary to my learned friend's submissions, there's nothing in the various occasions on which this was reviewed to suggest that there was a conscious intention to oust the jurisdiction of the tribunal. You were taken to the explanatory notes to the 2015 regs, and page 2003 in particular. And in the interest of time, I won't ask you to read it now, but in the course of your deliberations, it's perfectly clear that the focus was on a beleaguered service complaint system, and therefore the response to that by way of the ombudsman scheme. And the reference to adequate alternative remedies, which would nonetheless be available, is a reference to something which is not the service complaints regime itself. On any reading, that's perfectly capable of constituting the continued access to the Employment Tribunal. And an important indicator in my submission that there's no, contrary to my little friend's submissions, on a careful delineation, he has to accept, or indeed he has to posit before this tribunal, that the role of the ombudsman changes depending on whether the contravention is pre or post-service. Post-service access to the tribunal, pre-service, the ombudsman becomes the principal arbiter of civil rights and obligations. 2 short points. SCARF may not know when exercising its discretion as to whether to undertake a review at all. And the submission that she puts before this court very much belies the suggestion that there's any deliberate intention to that effect at all. Finally, on construction and then declaration, I would say this. My learned friend overstates the range of options available to resolving any incompatibility. By way of the 2015 regs and its predecessors, the armed forces have legitimately made their bed, which is that they do not wish to entertain service complaints about anything arising in the course of service complaints. If following this judgment, the Undersecretary or any relevant minister would wish to put the genie back in the bottle and impose some other guise of procedural bar on access to the tribunal, so for example, that there must be a need to enunciate any discrimination in an appeal, or that for the first time a requirement to refer to SCARF is imposed, then that's something which can legitimately be done. But the approach taken by my learned friend again puts the cart before the horse. Those steps could and should be reflected, or should be considered, in the wake of a judgment from this court that the current regime offends basic and fundamental convention rights. In other words, if the effect of a decision from this court that the current state of affairs is impermissible, that there should be no bar on access to the tribunal once the complainant has done all that which the current regime requires. It's perfectly open to any affected Secretary of State to say, well, in view of that, we'd like a further opportunity to rectify the issue internally. But to leave the void in my submission is not acceptable. And nor can it be said that the far parameters of disapplication of subordinate legislation envisaged in R&R are met. finally, on declaration, the effect of upholding the MOD's position would be to say this, that it's impossible to read section 121 in such a way that excludes the scenario where the service person has done all that is required and not presented a service complaint because they're statutorily incapable of doing so. One need only say that out loud to realise that the parameters of section 3 are not exceeded. But if the court reaches that conclusion, then plainly the issue is with section 121 itself. And the effect of section 121 being informed by subordinate legislation. The effect of that, in my submission, is that this is a case in which a declaration may, can, and should be made, should all else fail. On my learned friend's submissions, it rather seems as though the making of such a declaration would focus minds, where on any view of the morass of material that this court has before it, there has not been, in my respectful submission, the joined-up thinking which one would expect. My learned brothers, unless there's anything else I can do to assist.
Can I just ask you about the point on the chronology, page 44? Your client's first claim in the Employment Tribunal, that's about sex discrimination by other service personnel, nothing
Yes.
to do with the hearing, was filed in May 2020, and it was stayed in November 2020 on the joint application of the parties. And is that it? It's been stayed ever since. So there's never been a hearing on the merits of the sex discrimination claim, going back to a period beginning before 2018, continuing.
No, indeed. And that's why we caution some measure of caution against uncritical acceptance of the suggestion that all complainants agree, or claimants agree to the stay of tribunal proceedings. That very often, certainly in the wake of considerable delays in the SC process, and this is an example, they don't, and they certainly don't at the moment, is my experience. But, my lord, you're quite right, there has been an extraordinary delay.
7 years and nothing at all has happened.
But she did agree to the delay in this case because it was a joint application for stay.
Well, it was unopposed, and clearly the delay in the appeal process has been unforeseen. But yes, the delay is one which is regrettable, to say the least.
Yes, right. No. Thank you all very much. Won't come as any surprise to you. We're going to reserve judgment. And nor will the next thing I have to say come as any surprise to counsel. We will send out a draft judgment. Draft not in the sense that we're asking for further argument. We're not. Draft only in the sense of inviting corrections of typos and dates and other obvious factual errors. We will expect any ancillary matters to be dealt with in writing. We will then formally hand down judgment in the digital sense, i.e. put it on the National Archive. Until it appears on the National Archive, the contents of the judgment are confidential to clients on each side, including obviously the appellant, those who need to know in the MOD and the two legal teams until it's made public. Thank you all for your very great assistance, both orally and in writing.
Court rise, April.